Okay, so Mr. Segura, when you were here and entered the plea of guilty, asked you some specific questions about pleading guilty freely and voluntarily, and then pleading guilty because you actually did what they charged you with, and your answers to both of those were yes. The version, however, that your version that I received here in the sentence report is a little different. It says that you didn't have the drink until your vehicle was stopped. And so your version, if I'm to believe it, is that you stopped at the Taco Bell.
Yes.
You drove to the Taco Bell.
I drove to the Taco
You stopped at the Taco Bell. And you drank while your vehicle was stopped.
No, ma'am. I was outside
So you hung out at Taco Bell
I was
and drank.
I was waiting for the line and we were talking, trying to get my food.
Yeah. Let's do that. Raise your right. You swear or affirm that the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
So help me God.
Okay. So you're saying that you got to Taco Bell. You drove to Taco Bell.
Yes, ma'am.
Okay.
I made a right turn. With my kick on everything. And I was about to park. I feel. That's where the swerve came in. Okay, obviously, it happened. And so.
I'm not worried about. Hold on.
Yes, ma'am.
Right. I want to know when you got to Taco Bell, regardless of whatever happened.
Right.
Did you go through the drive-through or did you park?
No, ma'am.
Listen to my question. Did you go through the drive-through or did you park?
I parked.
Okay. So when you parked your car at Taco Bell, you start having alcohol at that point?
No, ma'am. I got out of my vehicle to see how far, traffic was
Okay.
He had some car in front of me.
In front of you for what? You were parked.
Yeah, I was parked.
Were you parked in a parking spot or were you parked in the drive-through?
I was not exactly in the drive-through. I was in front of the store. At the end of the store.
Okay.
Right. I guess sitting there to drive through line.
Were you waiting for the drive-through?
I was waiting for the drive-through.
Okay, listen, here's the thing. You're not going to try to trick me up with semantics.
No,
hold on, don't talk over me.
Yes.
When I say, were you going through the drive-through or were you parked? What does that mean? That means, did you park your car because you're going to go in the store, or were you waiting in the line to go through the drive-through?
Go through the drive-through.
Okay. I may look.
This is where things border on surreal. The claim that the drinking started after driving, while waiting in a Taco Bell drive-thru. Courts hear creative explanations all the time, but this judge shuts down word games immediately. Parked versus drive-thru isn't semantics. It's the difference between lawful and criminal conduct.
I don't know, like I'm 12 years old and just fell off the turnip truck, but I'm not. So you're in the line, and you get out of your vehicle, right? Because there's a long line, the cars aren't moving.
Right.
Right. So you get out and you decide you're going to start drinking here in the park.
No, ma'am, I didn't drink until I got back in the car.
Okay. But while you were at the Taco Bell, you started drinking. Had you drank before that?
No, ma'am.
So you're telling me that you started drinking at Taco Bell?
Yeah, I was thinking that's how the year. Yeah, it was on.
So from the time that you started drinking at Taco Bell to the time that the officers got there, about how long was that?
Maybe 15, 20, 30 minutes, whatever.
Okay. How much did you drink between that?
Yeah, kind of all that.
Mm-hmm.
Yeah, it was a strong beer.
Mm-hmm. Just one?
It was a 40 ounce.
Right. So you drank the whole 40
I was
ounces.
drinking out of the, after the fact that
You were drinking out of what?
I got back in the car and I started drinking.
Right. So how much of it did you drink?
Soon as I
Okay, so let's just say you drank most of one 40 ounce.
everyone can entertain
So that's your story and you're sticking, hold on. So is that your story and you're sticking with that you drank most of one 40 ounce beer in about 15 to 30 minutes and that you hadn't drank anything before then?
No, except for the night before. About 2 o'clock that morning. In whole blood, alcohol stays in the place. 32 when I drank.
Okay. So your test on this night after drinking most of 40 ounce was 0.188. And you're wanting me to believe that that's based on most of one drink, and that maybe you still had alcohol in your system the day before.
Yes, ma'am. But what I remember because my memory down, I have no business trying to put you in this way. I'm telling you, God's son is true. Like I said, I ain't alcohol business from the night before.
How much did you drink the night before?
Well, I was intoxicated.
So what you're telling me then, if you had that much alcohol in your system from the night before, that you were still probably hold on. Watch where your story's going.
Yes, ma'am.
So you're telling me you had so much in your system the night before that it was going to still be in your blood, and you had just driven to the Taco Bell.
No, I drove to the Taco Bell at later on that evening.
You're not right.
It wasn't a full 24 hours.
Right.
Right.
So if you're saying that 0.188 is because of the night before, then all likelihood you were drunk when you were driving from the night before, if I'm to believe your story that you only had most of one drink while you were there. See how that doesn't make sense?
Here's the science moment. A blood alcohol level near 0.188 doesn't magically appear from most of one beer, especially not in a chronic drinker. The judge walks him straight into the logical corner. If the alcohol came from a night before, then he was already impaired while driving. Either way, this defense collapses under its own weight.
Okay. All right. So let's go back. Obviously, there's some medium acceptance of responsibility, so we can go forward with the argument. Unagreed, Mr. Burbank. I'm sorry, Mr. Coleman, you have a witness?
Constable Robinson.
Mr. Robinson, if you please raise your right hand, sir. Do you swear or affirm the testimony you're going to give hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may proceed.
Of course, familiar with Mr. Robinson's background.
Sure.
Mr. Robinson, you said I
Almost sure.
you had up to be reduced an application to this case. The include file judgments for a new marking commission. The choice was marked states exhibit number 1. It states exhibit number 1 here. That is a summary of 20 felony judgments you used. Take your 20 previous file judgments. So the chamber of no policies. The commission to use one of the DOI to take and it's good compare to judges here again. What would you in addition to the prayers to compare and confirm the identity on the scene, were also identifying institutions of the seat numbers and used to the this time I would offer states number 1, which is summary, and the actual judgments themselves marked states
Let me just ask, are there any on that list that aren't already on the pre-sentence report? Why are we doing that?
It's been a while.
Mr. Burbank, does your client hold on? Does your client have any objection or any reason not to for me not to take judicial notice of the PSI for sure that those prior offenses listed in there, the ones that are convictions, are any way wrong? Okay, so what about for the felonies? Are there one or more that are He contests.
Catch 22.
Okay.
This is quite not true to us, so that you got to.
Oh, okay. So,
Yeah. So it's two felonies that I think are crucial.
all right. So then, do you have any objection to the states? Was it 1 and 2?
Stage 1 is fine.
I object to states one because it's not true. Let's do it.
Okay. My main concern are the felonies. And if you have the actual judgments on those, why don't we do that way, even though it might be a little more documentation, Mr. Coleman? If you will go through primarily the felonies, is my concern. And
I'd like to read summary and just the felonies as a backup. Because I want to look at the court to do the summary. I want to out the street.
well, I want to talk. I mean, I've got the pre-sentence report, so I need to know if there's something in the summary that's not in this report. That's what I'm kind of used to looking at. I've already made my notes on it. I've got highlights. So if there's something that's not on that already, let me know. If it is, then obviously I will. Are that there are 19 misdemeanor convictions on the pre-sentence report, and that I've got 8 felony convictions.
I think you won't have 8 judges. I think that there's at least one of them that was accused with PSI or
Stop, don't let us figure it out. So what I show with convictions on the PSI, I've got a 91 possession of a controlled substance. There was probation that was revoked by TDC. Got a 96 manufacturing delivery of controlled substance, 1 year jail. I've got a 03 possession of a controlled substance, 18-month state jail. Got an 03 April manufacturer delivery with 6 months state jail. I've got a January of 15 obstruction or retaliation to TDC. Got at the same date a harassment of a public servant to TDC. Got a driving while intoxicated, there were more. Offense date of 11 of 15, 3 TDC. And then I've got an 18 obstruction retaliation with 5 TDC. Totals 8 felony convictions.
That's 4 than what I had.
So are there then, I need at least whatever you have, because he has pled not true to the ones alleged in the indictment, which, hold it.
There's state 5.
They have a room.
Yes. Give him a second.
So,
Documents right there, state.
Hey, Mr. Burbank, you asked a question. Let him answer the question.
Yeah.
Calm down.
Would.
He's on it. I'm sure. Mr. Robinson?
listen. So, what I did is I took, that he had pled to. I used to be print off of this. And all that was supposed to do. And then I compared these documents to this document to the rest of these documents. Some of them have fingerprints, some of them do not have fingerprints. They, however, all have name, date of birth, and manufacturer information, which is what I compared to.
So, in does state 5 have the thing? How did you, do state 5?
Some of them don't have them.
Okay. Go ahead. Let me also kind of stop, because there might be, right now, I told you to kind of focus in on the 3 that are in the indictment. The state did file a notice of intent to use prior convictions to enhance punishment back in January of this year of 2024. And so that motion lists it lists 6 felony offenses. So we obviously need to go through these 6 potentially as well. here's what I want to do. We're going to take I want to take a quick break. I'm going to take care of this other matter. Y'all go through, get it organized on 6 that are in that motion. If any that are in that motion are not duplicative, I want to know which ones are duplicative of the ones in the indictment so that we're not talking about them twice. If there's 3 in the indictment, and those are included in the motion, some of them are, some of them aren't, be ready to tell me so I can know which ones we're going through so that I know if there's 6 that are being proved up, if there's 8 or 9 that are being 8. I show 8 on the PSI, potential felony priors. So I want to know kind of where we are and all that. Y'all can just go sit down and take a break. Don't leave the courtroom, Mr. Seur.
You're always listening.
There, because it was reduced, there wouldn't be a.
We're not seeing this happening.
Now we enter enhancement territory. Prior felony convictions don't just add context. They reshape the punishment range. This isn't about retrying old cases. It's about legally proving identity so the court can sentence harder. Fingerprints, dates of birth, certified judgments. This is how the state turns history into leverage.
Date of birth is correct. Name appears correct. So.
That is correct.
Let's get Robinson. It's fair to say that Mark Anthony Seur is a unique name. It's not like we're talking about Mark John.
I don't know any other ones. Yeah.
Put your hand down. And Mr. Seur, sitting there thinking that me asking these questions is somehow on your side
Okay.
and making the head nods and all the things that are going on, you need to stop.
No.
It's not helping.
Yes. No.
So here's what we're going to, hold on. Here's what we're going to do. Mr. Seur, I want you to remain here in the courtroom.
Yes.
Mr. Coleman, I'm going to recess this hearing until 1 o'clock. When we get back at 1 o'clock, during lunch, I need it all ready to go, lined out, whatever. If you want me to take it into consideration, now I've already taken judicial notice of the PSI, but if there are objections, this is not him, then this is what I'm asking you to do, Mr. Burbank. Specifically go through the PSI, or actually specifically go through the second amended notice of intent. And I want you to go through that, and I want to know which of those, and if it's all of them, that's fine. But if you're saying that this is not him, it's someone else, then I want to know that. If you're saying it's not admissible because of some identifying factors, I want to know that.
Well, I believe the ones that are arguing about the first issue one.
So then we're arguing right now about a misdemeanor. If we're not going to argue about misdemeanors, are there any on the list of misdemeanors that you were arguing that are not Mr. Seur?
No.
All right. So then, do you have any objection to my taking judicial notice then of the PSI, which includes 19 prior misdemeanor offenses?
No.
Okay. Then we can stop with all the misdemeanors. I don't even need to see those judgments. Are there any other felony? I have 3 in front of me now. Any 2? States 2, States 6, States 7. I have States 2, 6, and 7. These are all 3 third-degree felony offenses that have been admitted in evidence. I have not made findings yet, but they are admitted. With regard to other felonies that you want me to take into consideration for punishment purposes, not necessarily enhancement, I know you said there was state jail that you kind of stopped on. Are there any?
There are state jails for punishment. I think hit the limit on him.
Okay. So with regard to the state jail, Mr. Burbank, it looks like on the PSI, I'm looking back now at the PSI, it appears that 2 of the several felony offenses, only 2 of them appear to be state jail felonies.
Most back in 2003.
Correct.
Received 18 months.
And 6 months. Is there an objection
No.
to those, or me taking those into consideration, or any that's not Mr. Seur?
No.
All
There's
right.
also one in 96. that I'm not sure of. It said 1 year, right? So that's the list.
That would have been probably before state jail, so I think that's the one that might have been reduced that they were talking about. So that one I'm not taking into consideration as a felony. I am taking it into consideration as a less included or a reduction, whatever it was, that to that jail time county. Okay. Perfect. No, let's keep going. So that means at this time, then, based on the evidence, do you have any evidence, Mr. Burbank, with regard to the findings that I'm going to make on count States Exhibit 267?
One that is a two judge.
Right. So, I mean, I know you had, I don't remember now which one, but
The ones I found, the ones I had objection around, would be sufficient.
Okay.
Identified. That's not it.
then at this time, I am going to, based on the evidence that has been included in the PSI as well as States Exhibit 2, 6, and 7, I'm going to find that the prior criminal offense felony in cause number 15-23847, which is number 15 in the state's enhancement, is true. I am also going to find State's Exhibit number 6, which is cause number 15-22572, which is number 14 State's Notice of Enhancement, make a finding that that is true. In addition, State 7, which is cause number 18-30235, which is number 16 in State's Notice of Enhancement, I am also going to make the finding that that is true. So that are those 3 prior felony offenses. I have made findings of true. I am taking into consideration all of the other ones, with the exception of State's number 5, which has not been introduced, but that was we discussed, which is cause number 60328. I am going to make a finding of not true because I don't have enough evidence, and that it sounds like in that judgment to link Mr. Seur well enough to that offense. Everything else, I'm taking notice of for punishment.
Is that for 2096 PSI, in which he received 1 year before we was.
I just said that a minute ago. So in 96, I'm taking notice that that was reduced and is not a felony. So what that means is that it appears as though there are this would be the maybe this. All right. So yes, judicial notice that that one was reduced from a felony to a misdemeanor back on the conviction date of 96. Right. So, Mr. Burbank, you may proceed with the argument.
May I call my client?
Yes, and he's already been sworn in. Thank you, Ms. Roberts. Go ahead, Mr. Seur, Mr. Burbank.
Earlier today, Mark, you found what comes. Tell the court why. What are you asking for? Let's start with that.
First of all, Jill, he comments for mercy. Begin with. Well, I was very personal. So once you account for all of my kids, I worked all my life. Kids is out.
Where do you work?
I work short. Starting off, I worked for Leo Willis when I was a kid. After that, I graduated and I continued working. I've been working in the plant for over 30 to 40 years. All my life I've been working.
How many years?
Yeah. And all different types of jobs all over.
How many years did you serve? How many years have you been?
Most of them,
How many years have you
all together with everything. I would be over.
Okay, how old?
I'm
58 years old. 10 years. You've been DWIs and other things. So what mercy are you asking for from this court when you have 19 misdemeanors, 7 or 8, 6 or 7 felonies? What kind of, why should she consider something less? Give her a reason why. What's changed?
I didn't do anything. Yeah.
Mark, plead guilty to him. Okay? That's over with. Right? The day for you in reference to court, the day for you to say, I didn't do this is over. You accept the plea. Okay? Now let's come to the chase here. Because she could find the allegations of what she did is true, and consideration is 25 to 1. Right? And, I guess the most you had up to 45, right? Okay. So now let's go first to when you were arrested. Were you working? Okay. What is your disability?
I got room to capacity. Like it's great.
Life disability? Okay. When did you first have disability?
Like 2020.
Okay. So 2020, you're on disability. So while you're on disability, why are you drinking the 40 ounces at a time? Or drinking the night before to where you're coming?
No, it's I lost my just lost my brother. I was going in my phone. And alcohol just got no good.
Thank you, no problem. One of the things you talked about was what you came to me was that you never went to a program.
Yeah.
You never went to a drug program?
Yeah. I never did things on posts.
Well, you got
Well, what about when you weren't on probation? What about the times when you weren't in prison and you knew you had a problem and you wanted to stay out of prison?
Well, I device something else.
No, what? That's since you've been in. I'm talking about the rest of your life. I'm talking about the times that you got arrested 43 times for public intoxication, 39 traffic offenses, 17 times you didn't appear in court, 5 disorderly conducts, 4 opening containers. I mean, these are the ones that aren't even listed on pages. Pages.
Yeah, well, I'll do another one.
Okay, so you're gonna stick with that this isn't you.
No, I'm not making no excuse. I very much have respect for
Oh, but
your law.
okay. Do you really? You
Yes,
do?
ma'am,
So that's the 19 misdemeanors, the assaults, the terroristic threats, the trespassings, the 1, 2, 3, 4. This is your 5th DWI, your 2nd felony DWI. By what you need to understand is that by not really taking personal responsibility and making us go through this circus that we've been going through now for an hour and a half of trying to prove that you actually have been convicted of felony offenses when you know darn well that you have.
You can feel the courtroom tension snap here. The judge isn't angry about the crimes anymore. She's angry about the denial, making the court jump through hoops to prove what everyone already knows is seen as disrespectful. And in sentencing, attitude matters almost as much as evidence.
Makes no sense to me. Mr. Coleman? Argument?
You have it.
Go ahead.
One of the things referenced in front is somehow I thought this was I did not get your Quite cheerful. 30, 25, July. He's got a problem. He spent most of his life in and out of his alcohol. I feel one thing out of Judge is alcohol. He was his vehicle. He plays a lot of things for information. Find truth in the allegations about something safe. But screws up, he's looking at 25 July to deal to find those truths. Find it comes back. Here's the problem is that we don't know what happens when it comes to particular violations. Reference. I've done it before, Judge, in other courts when confirmed.
You can't give deferred on a driving while intoxicated. Now, we've done that on other types of offenses, but I can't do it on this. That's not an option. Okay. All right, thank you. Mr. Seur, you're starting with the beginning of this hearing when we were going through the just the nature of the offense. Starting there, we went down the wrong path. It makes no sense. I don't believe it. It doesn't add up to what your blood alcohol level was. How you say what happened that night doesn't line up. It just doesn't. I get that 40 ounces is big beer, but if you've been an alcoholic for as long as you're talking about, that's not going to get your blood alcohol to what it was that night, which was almost a 0.188. I have already found those 3 prior offenses true. Those are all felony offenses of different conviction dates. I'm going to find that you previously entered a plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated, third or more. I'm going to sentence you to a term of 25 years in the Institutional Division of the Texas Department of Corrections. In my opinion, you're lucky that Mr. Coleman asked for 25, because I'm not sure that you really even deserve that with your criminal history and with...
This is the final reckoning. With prior felonies proven and responsibility rejected, the floor becomes the ceiling, 25 years. Not probation, not treatment, prison. The judge even makes it clear this could have gone worse. In Texas, habitual DWI plus felony history is the end of second chances.